Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here already, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Liquidated Damages for Late Delivery of Vacant Possession under the Housing Development Act. My name is Daphne Ratwal. I'm an associate with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises 28 lawyers and a support team of 21. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small and medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, the dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Our speakers today are Hannah Patrick and Ryan Cheong. Allow me to introduce our first speaker. Hannah is a senior legal associate in our dispute resolution department. She was admitted to the High Court of Malaya in 2013 and to the High Court of Sabah and Sarawak in 2017. Hannah practices in the areas of general litigation, construction law, debt recovery, corporate litigation, and intellectual property. Our second speaker, Ryan, is an associate in our dispute resolution and general litigation departments. He was admitted to the Malaysian Bar in 2021. He obtained his Bachelor of Laws from the University of Reading, UK, and went on to complete his bar professional training course at City University of London. Ryan's areas of practice include general litigation, debt recovery, construction litigation, arbitration, adjudication, and corporate litigation. We will also be having a Q&A session at the end of the talk, so please feel free to post your questions in the Q&A chat box at the bottom of your screen. Over to you, Ryan.
Hi, everybody. Today's talk is for the liquidated damages for late delivery of vacant possession under the Housing Development Act. So I'll be taking the first three talk points, which is the relevant provisions under the HDA, the effect of the booking form on the calculation of liquidated damages, and the exemption period under the COVID-19 Act. And my colleague Hannah will be taking the next two talk points. So first and foremost, and beginning with this Development Act is the ultimate regulator of the regulations in West Malaysia pertaining to housing developments. In fact, the preamble in the HDA clearly states that it is an act to provide for the control and licensing of the business of housing development in Peninsular Malaysia, the protection of the interests of purchasers and for matters connected therewith. So essentially, the HDA protects the interests of residential home buyers against developers for a specific period of time. Now, this protection comes in the form of regulating the defect liability period, the management of strata title issues, to safeguard fire-related conflicts, and to regulate claims against the developers. Now, it is important to note that the HDA only applies in West Malaysia, and it is considered a social legislation by the courts. Now, what is a social legislation? First and foremost, it means that the Parliament passed the HDA with an intention to ease or to facilitate the affairs or to protect a certain section or a group of persons. In other words, it would be a set of laws passed by the legislature to regulate the relationship between a weaker class of persons and a stronger class of persons. In this case, the weaker class of persons would be the purchasers, and the stronger class of persons would be the developer. So now we'll move on to talking about the purpose of the HDA. First and foremost, as mentioned earlier, the HDA is designed to regulate the business of housing development. It is to prevent purchasers who may not be fully aware of their rights from being exploited by developers at the purchaser's detriment. But the most important purpose of the HDA, so to speak, is to provide standard form of sales and purchase agreements through the Housing Development Regulations 1989. So in other words, no matter if a home buyer buys a landed residential property, like a terrace house, or a subdivided high-rise building, such as a flat or a condominium, the developer must adopt a standard form of SPA prescribed by the HDA. So the developer cannot enter into an agreement with a purchaser which is made on their own. It has to be adopted from the HDA. They don't have much leeway to amend the SPA or go on a frolic of their own. So now I'll move on to the relevant provisions of the HDA. So what is a housing development? Well, first and foremost, a housing development is anything which is more than 4 units of housing accommodation. And it must be developed or constructed with the collection of monies in mind, and there must be building operations for the purpose of erecting building accommodation. So it is important to keep in mind that a development must be more than 4 units of housing accommodation. So now moving on, what is a housing accommodation? A housing accommodation is any building which is wholly or principally constructed, adapted, or intended for human habitation or partly for human habitation. So think of any common flat or apartments or condominiums or landed property which was developed for human habitation or partly for that is a housing accommodation. Now, under Section 3A of the HDA, we all have to note that the minister has the power by publishing in the Gazette to prescribe any type of accommodation to be a housing accommodation. As we mentioned earlier, a housing development is something more than 4 units. And it could be a flat, it could be an apartment, any development. But the minister has the power to determine any other group of housing accommodation to be a housing accommodation. So it might not necessarily follow the definition of what we have just explained. And the minister's decision in this respect is final and cannot be questioned by the court. Now, the other most important provision of the HDA is Section 24. Under Section 24 of the HDA, the minister has the power to make regulations for the purpose of carrying into effect the provisions of the HDA. So the minister may make regulations to enforce the provisions of the HDA and to give them effect. The minister has a wide range of powers, and amongst these powers, they can regulate the terms and conditions of the contract between a developer and a purchaser. As we mentioned just now, there are standard forms of SPAs that the developer must adopt into entering into a contract with a purchaser. But the minister may regulate these SPAs. So the minister may provide for an exemption from the operation of the HDA in the said SPA, or it might add terms which it deems expedient. So the minister has the power to regulate the standard form of SPAs. Now, we spoke about the HDA, and now we have to move on to the HDR. So, as mentioned earlier, Section 24 provides the minister the power to make regulations. The HDA are the regulations, the HDR, are the regulations made by the minister. So in the HDR, there are numerous standard forms of sales and purchase agreements in Schedules G to J. Now, all of these schedules contains clauses on the delivery of vacant possession and the completion of the common facilities. For the purposes of today's talk, we will be focusing on Schedule H, which is for high-rise buildings, and we'll be mainly speaking about calculating liquidated damages due to the late delivery of vacant possession. Now, I think it's important to go through the various schedules before we move on. To safeguard purchasers, there are different schedules for SPAs under Regulation 11 of the HDR. So the first Schedule G is for landed properties, which are sold and then built. So purchasers will enter into a SPA with the developer before it is built. These are purely for landed properties. Now, as compared to Schedule H, the delivery of vacant possession for Schedule G is 24 months, not 36 months. Now, Schedule H is for high-rise properties. Again, the developers would sell these parcels of units and then build the parcels. So, as most of you are aware, the delivery of vacant possession for Schedule H is 36 months. Now, there's also Schedule I and J. Schedule I is for landed properties, which, differently from Schedule G and H, is built and then, and Schedule J is for high-rise properties which are built and then. So we'll be focusing on Schedule H today. Now, what are the relevant clauses in Schedule H? The first important clause is Clause 8, where it is stated that time is of the essence. So what this means is that the developer has to endeavor to comply with the 36 months period to deliver vacant possession. So that time frame to deliver vacant possession is very important, and it's of utmost importance. Now, moving on to Clause 25 of Schedule H, it says that vacant possession of a parcel shall be delivered within 36 months from the date of the SPA. So let's say you entered into the SPA on the 1st of May 2022. So vacant possession of that parcel, the time to deliver that is of the essence, and it should be delivered within 36 months, which is 3 years. So in the event the vacant possession of the parcel that you bought is not delivered within the said time, the developer is liable to pay liquidated damages to the purchaser from a day-to-day basis at 10% per annum of the purchase price. Now, the period of calculation would be from the expiry of the date of delivery of vacant possession. That means 3 years from the date of the SPA until the date the purchaser actually takes vacant possession or receives the notice of vacant possession. Now, Section 26. Under Section 26, the developer shall provide vacant possession to the purchaser upon the 3 following conditions. First and foremost, the certificate of practical completion of the whole development must be issued. Secondly, the water and electricity supply must be ready for connection. Obviously, you cannot pass on a parcel without water and electricity. And the third would be a purchaser has to pay all the monies under the relevant schedule of payments. This is done by giving the purchaser a notice of vacant possession. Once you receive the notice of vacant possession, you may take possession of the said parcel. When will you be deemed to have taken possession of that said parcel? Well, upon the expiry of 14 days from the date of the notice, you will be deemed to have taken possession of the parcel, regardless of whether or not you have actually taken the parcel. So it's important to note that all purchasers would be deemed to have taken possession of a parcel within 14 days from the date of the notice. Section 27 speaks about LAD in relation to the common facilities. So it says that the common facilities serving a development shall be completed by the developer within 36 months from the date of the SPA. This is again 3 years from the date of the SPA. Should the developer fail to do so, LAD will be imposed from the supposed completion date until the actual completion date of the common facilities at a rate of 10% per annum on only the last 20% of the purchase price. So it's important to note not the whole purchase price, but just the last 20% of the purchase price. So now let's look at an example of calculating LAD. Well, let's take Ali for an example. He bought a flat in an apartment in a development. And so obviously because he bought a high-rise building, Schedule H applies to him. Under Schedule H, the developer has 36 months to provide vacant possession of the parcel Ali just bought. Let's say that the date of the SPA was on the 1st of January 2015. Taking 36 months, vacant possession should have been given on the 1st of January 2018. This is 3 years from 1st of January 2015. Now let's say that the developer gave the notice of vacant possession a year late. So instead of Ali taking possession of the house on the 1st of January 2018, he took it on the 1st of January 2019. Considering that the purchase price is 600K, so to calculate LAD for late delivery of VP, you would take 10% per annum on the purchase price. As we said earlier, this is the rate under clause 25. And for the common facilities, you would take 10% per annum on the last 20% of the 600K. All in all, there is a 365-day of delay. So for the late delivery of the parcel, we would take the period from the 1st of January 2018 until the 1st of January 2019. But as mentioned earlier, this is 365 days. So the purchase price, 10% per annum at a rate of 365 days, you get RM 164 per day. So taking this RM 164 per day multiplied by the 365 days, you get 6,000 days, 6,000 ringgit LAD for just the late delivery of the parcel. Now, the common facilities is, the period will be the same. There's a year delay and there's a 365 days of delay. So we would take the last 20% of the purchase price, which is 600K, times 10% per annum, and we will use that rate, which is RM32 a day, and you multiply it by 365. So in essence, that gives you 12,000 ringgit for LAD. We would add these two together because late delivery of vacant possession almost always means that the facilities were completed late as well. So we would do this calculation and we would end up with a total of 72,000 ringgit worth of LAD for Ali's house. This is the standard way of calculating LAD. Now, recently, there has been issues of booking fees. So under Regulation 11.2 of the HDR, developers are prohibited from collecting booking fees. What is a booking fee? A booking fee is a fee charged in addition to the purchase price. This is solely for arranging in advance the accommodation, building the parcel, whatsoever. Although under the HDR, developers are not allowed to collect booking fees, it remains a common practice for a lot of developers to request payment for booking fee. It is not unusual for an SPA to be executed after the payment of a booking fee. So you could pay the booking fees almost a year before you execute the SPA. And under the law, this is actually unlawful. So recently, in the case of PJD Regency, it was decided that should vacant possession be delivered late, LAD should be calculated from the date of the booking fee, not the date of the SPA. So as mentioned earlier, if vacant possession is delivered date, we will usually take the date of the SPA and calculate when vacant possession is actually given. So under PJD Regency, we do not use the date of the SPA anymore. We use the date of the booking fee. This is because the court was of the opinion that if the date of the SPA was taken instead of the date of the booking fees, the developers would be able to bypass the statutory protections afforded to the purchaser. As mentioned earlier, the statutory protection here would be that developers are not allowed to charge booking fees. So if you charge booking fees and LAD is calculated from the SPA date, then the provisions made by the legislature was not given effect to. The court was of the opinion that they must give effect to these statutory provisions. So therefore, the term for calculating LAD, which we used earlier, which is from the date of the SPA, has been extended to from when the payment of the booking fees was made. So this may be a bit confusing. So there's another example. Now let's take Ali's house again. The purchase price is 600K. And as we said earlier, the SPA was executed on the 1st of January 2015. Now, Ali paid booking fees a year earlier on the 1st of January 2014. From the example earlier, if we take the date of the SPA, vacant possession is supposed to be given on the 1st of January 2018, which is 36 months from the 1st of January 2015, which is the date of the SPA. But because booking fees was paid on the 1st of January 2014, we should take 36 months from the 1st of January 2014. So the supposed date of VP is now the 1st of January 2017, which is 36 months from the day you paid your booking fees. So because of that, the LAD liable to be paid by developer will be much higher because you have a whole year more worth of delay. That is the applicability of booking fees to calculating LAD. Now, recently, due to COVID and the delay, Section 35 of the COVID Act actually excludes the period from the 18th of March 2020 until the 31st of August 2020 from calculating the time of delivery of vacant possession and from calculating LAD for the failure of the developer to deliver vacant possession. What this means is that the time period from the 18th of March 2020 until the 31st of August 2020, the amount of days within this period will be totally abolished from calculating when VP should be delivered or when LAD should start, or from when LAD will start to accrue. This exemption period is given as of a right. There is no need for developer to apply for this exemption in regards to calculating LAD. However, the developer may further apply for a further extension should this period be deemed not enough. So, in making such an application, you must make an application to the minister to exempt further the period of 1st of September 2020 until the 31st of December 2020. It is up to the developer to accept or reject this application, but the minister does have the discretion to exempt a further period. Let's look at how LAD is calculated considering the COVID-19 exemption period. Let's say that Ali's sales and purchase agreement was dated 1st of May 2017. Now, following Schedule H of the vacant possession should be given within 36 months. So that means that Ali should have gotten his house on the 1st of May 2020. Let's say notice of vacant possession was given 2 years late. So notice was given on the 1st of May 2022. In the circumstances, without considering the exemption period given by the COVID Act, there are a total of 731 days of delay. To calculate LAD, we will take 731 days multiplied by the rate, the earlier rate that I mentioned. But if we include the COVID-19 Act exemption period from the 18th of March 2020 to the 31st of August 2020, we would have to take off 180 days from the said 731 days. So in calculating LAD, the rate that we mentioned earlier would be multiplied by only 565 days. So in essence, we will need to deduct that amount of days from the calculation of LAD. Ultimately, these would entitle purchasers to less amount of liquidated damages if vacant possession was given late. Now, I'm done with my top points. I will be handing over the floor to Hannah.
I will now go into the cases, case here being court decisions. I will be focusing only on extensions of time and LAD. Before I go to the cases, let me just take you through the nature of extensions of time. Extensions of time for the delivery of VP are usually granted to developer by the Ministry of Local Government and Housing, or KPKD, you may be more familiar with that, through the Controller of Housing, via Regulation 11.3 of the regulations. Now, sometimes these extensions are allowed by the minister himself. These are usually granted pursuant to appeals under Regulation 12 of the regulations. And these will be case studies on to see how the courts have treated the extensions of time given either by the controller or the minister. I now take you through Regulation 11.3 of the regulations, just for us to give some context into the cases. Now, where the controller is satisfied that owing to special circumstances or hardship or necessity compliance with any of the provisions in the contract of sale, and this contract of sale will be your SPAs, is impracticable or unnecessary, he may, by certificate in writing, waive or modify such provisions. By way of background, usually when developers realize that they are unable to complete the project within the set time in the SPA, within, like for example, Schedule H, 36 months, they will apply for an extension of time from the controller, citing various reasons. There has to be some special circumstances or hardship, or that there is some necessity for the project to go beyond the prescribed time in the Schedule H, or any other schedule for that matter. But we're using Schedule H as the example here, prime example here, due to the vast cases in relation to Schedule H. The first and the highest authority on extensions of time by the controller would be the case of Ang Mingus, the KPKT basically. Now, the brief facts are as follows. On the 3rd of May 2012, the SPAs were signed, and these SPA are the standard SPA for 36 months. And then thereafter, after parties have signed the SPAs, the developer applied for extension of time. And at first, the controller rejected the extensions of time. And then thereafter, they appealed to the minister under Regulation 12. And eventually, the minister allowed the extensions of time. However, this decision, the letter which allows the extension of time, was actually a letter signed on behalf of the controller and not the minister. This extension of time was actually given pursuant to Regulation 11.3 that I have just mentioned earlier. So the main issue before the federal court here was whether the minister can delegate the power to modify the terms of the SPA to the controller. Section 24 of the HDA allows the minister to do such modification. However, can this power be delegated to the controller? And according to this case, the parliament has entrusted the minister to safeguard the interests of the purchasers. The court said that in allowing the controller to waive or modify the terms and conditions of the contract, it denied the purchaser's right to claim for LAD as prescribed by the minister under Schedule H, because Regulation 11.3 does not comply with the description of the regulations, which is designed to protect the interests of the purchasers. The court held that Regulation 11.3 is ultra vires the HDA, which simply means Regulation 11.3 is invalid. Therefore, the extension of time is also held to be invalid, and as it was given by the controller, not the minister. This case does not mention whether the extension of time or whether this entire ruling can apply prospectively or retrospectively. But in the absence of any mention, it is deemed to apply retrospectively. So you can imagine this is a federal court case which says that extension of time given by the controller, which has been the normal practice in the construction industry, is now considered invalid or void. So it has caused an influx of cases filed by purchasers claiming for additional LAD from developers who applied for and were granted the EOT under Regulation 11. So since then, since the case of Ang Ming Lee, there has been a number of decisions in the High Court, from the Sessions Court right up to the Court of Appeal at this point. There's been a number of decisions which both affirm and distinguish the Ang Ming Lee's case. So I don't intend to go through everything. There's a lot of cases. I will only pick out what are interesting and what distinguishes Ang Ming Lee more importantly. Okay, the first case would be a Court of Appeal case under UE and ENC Sanja. In this case, the EOT was granted in 2015. The EOT was for 36 months to 48 months. This was prior to the execution of the SMPs. Here, the court says Ang Ming Lee applies retrospectively. And the issue of whether the approval was obtained before or after the SPA was executed is not relevant. So it doesn't matter. According to this case, it doesn't matter whether your controller, your EOT, was granted before or after SMP was signed. The court held that the SMPs that was entered was clearly in contravention of Schedule H. The court also mentioned that the purchasers were not aware of the illegality of the SMP when they were signing it. In order to be fair to all parties, what the Court of Appeal did here was to declare the SMPs void for illegality. The relief for a void contract is restitution under the Contracts Act. And this is what the court has said. We are of the considered view that it is only fair and just to the parties in the present appeals to be put in their original position as if the SPAs had never been executed. So again, to just make it clearer for you, when the parties signed the SMP, they are saying that the purchaser did not realize that there was an illegality by virtue of that extension of time granted. But to be fair to all parties, including the developers in this case, the court decided to make all the SMPs, or rather the SMPs in this case, void. So the decision was affirmed by the federal court as the leave to appeal was dismissed. Now the thoughts here are then, if the SMPs were declared void, what then happens to the ownership of the housing units? Do parties have to re-execute a new SMP? These are questions that are still boggling us. We don't really know what happened after this case was decided, and it's been affirmed by the federal court. So the parties in this case, eventually the result of them was not more LAD, was that their SMP was declared void. The next Court of Appeal case I wanted to bring you through is the Blue Dream case. Now in Blue Dream, there's also 2 EOTs granted, but the first EOT was granted before purchasers signed, and then the second EOT was granted after purchasers have signed. To just briefly take you through, the first EOT was granted from 36 months to 42 months. And then the developer made a second application for EOT. This is from 42 months to 59 months. Now, this was after SPA has been signed. The controller allowed partially in regards to the second EOT, but only to the unsold units. So those who already signed the SMP will have to expressly agree to this amendment. And to no surprise there, none of the purchasers agreed to it. The developer appealed against the decision to the minister pursuant to Regulation 12, and the appeal was allowed. So this extension of time was from 42 months to 59 months. This time, the EOT was granted by the minister himself. So it's not just the controller, it's by the minister himself after the appeal was allowed. So the court took note that it was the minister who granted the decision, who made the decision to extend the second time. The first EOT was not in contention, or rather it was not really the issue in this case. The contention was really the second EOT. And the court took note that it was the minister who allowed it. So instead of looking at Regulation 11.3, which is still void or ultra vires, the court looked at Section 24(2)(e) of the HDA. So here the court said, in particular and without prejudice to the generality of the foregoing power, the regulations may regulate and prohibit the conditions and terms of any contract. So this would again be the SPAs under Schedules G to I. The court said the expression regulate and prohibit is wide enough to include waive and modify any provisions under Regulation 11.3. So the court looked at the fact that the second EOT was granted due to a stop work order, which ended up not being the developer's fault. If EOT was not granted, there will be a real likelihood that the project will be abandoned. And the court said that if the project was to be abandoned, at the end of the day, if EOT is not granted, it will not be in the purchaser's interest. So on this ground, the court actually allowed the appeal by the developer. And in this case, additional LED was subsequently not allowed because the modification was allowed to 59 months. I hope you are so far clear on the cases. I have more. I just wanted to pause and say, if you have any questions on the cases specifically, please go ahead and put them in the Q&A box. I now move on to the next case, Obata. Now this one, the facts of the case are that the ministry granted EOT from 36 months to 34 months. And you can see the July dates there. Those were the dates where SPAs were signed. And then the notice of VP was given on the 25th of January 2017. And what we must note is that the LAD were paid out via settlement letters. So that means this is quite also a normal practice where the developer and the purchaser will separately enter into a settlement agreement or a letter that settles the amount of the LAD paid. And then usually that is deemed case closed. Now, so this was an attempt to reopen that despite parties entered into a settlement agreement. However, the main issue here was the issue of limitation. Issue of limitation would be, very briefly, a claim on breach of contract is a statute barred under the Limitation Act if it was filed 6 years after the accrual of the cause of action. So basically, if there is an issue of breach of contract, the court will look at 6 years after the accrual of the cause of action. If it's beyond 6 years, a matter is considered statute barred. So in this action, the purchasers were challenging the validity of clauses 25 and 27 of Schedule H. Again, this was when I say amended clause, that means the clause that changed the duration of the VP from 36 months to 54 months. Because the purchasers were challenging clauses 25 and 27 of the SPA, the court then held that the cause of action ran from the date of the execution of the SMP. In this case, the 6-year limitation period ended in 2018. And because the suit was filed in 2020, the limitation has already set in. So the court did not even look at any other issues. The court just looked at limitation and said, sorry, no go, the matter is barred by limitation. Those were the cases in the Court of Appeal. I have presented to you 3 cases. I will now go to the High Court cases. The first one will be the case of Alpine Return and Matthew Ng Hock Sing. Now, this is quite an interesting case. This was filed by the developer, not by the purchaser. Now, this was an action filed by the developer to seek declaration that the SPAs were executed by the purchasers were valid. So obviously here there was an EOT involved as well, and the controller allowed it. But the developer was the one who asked the court to declare that the SNP entered into were valid. But in this case, what happened was that there was an EOT from 36 months to 60 months. The controller allowed the EOT after that, and then parties entered to SNP. And the delivery of the vacant possession was actually given within 16 months, which is basically within the amended delivery time, the extended time, basically. There was no late delivery in that sense. That's quite important for you to note for this case. The court in this case, the High Court, distinguished Ang Ming Lee on these 2 grounds. First, the court was of the view that the developer would not have undertaken the project if the extension not allowed. The court looked at the evidence and said, look, if 60 months was not given to the developer, 36 months would have been impossible. And then later on, the court also said the purchasers were fully aware that when they signed the S&P, it's 60 months. There was no like the developer going to apply after they signed the S&P. The court here said that there was no case of illegality or irregularity on the part of the developers. And then on the flip side, the court said that the purchasers, by relying on this case, is an attempt to unjustly enrich themselves. The court said then estoppel by convention must be applied. This may be a bit of a complicated concept. Basically, this is what estoppel by conduct means. Even though there is no disputing that the extension is not valid, given that Regulation 11.3 has been ruled to be ultra-vires. Now, what this means is the court said, okay, Regulation 11.3 is not valid. In situations like presently where the modification, such as the extension, was secured prior to the execution of the contract of sale. So in cases where the extension was received or were allowed before signing of the S&P, and if the extension was obtained without any illegality or irregularity on part of the developer, there is no concern about the need to ensure the protection and the purchases in the SPAs. So the court is of the view that if everything is actually in order, the doctrine of estoppel by conduct could be applied to prevent the defendants from now denying the terms of the as contained in the S&P. The purchasers already agreed to the term. This doctrine of estoppel by conduct stops parties from going back on the promise that they have made when they signed the S&P. The basis of estoppel by conduct is that a party has conducted himself that it would be unfair or unjust to allow him to depart from a particular state of affairs which another has undertaken to be settled or correct. So this one here basically means if parties have agreed that a particular state of affairs is settled or correct, in this case, the time for delivery is 60 months. It is unfair or unjust to allow him to depart from that. This estoppel against the defendants does not, on the facts of the case, have the effect of impeding the exercise of any statutory authority. So remember just now what Ryan was saying, that the whole purpose of HDA is to protect the interests of the purchasers. The court here is saying that the estoppel against the defendants does not mean that there is a diminishing or impeding the power that or the purpose of HDA, which is to protect the interests of the purchasers. Therefore, here the court says that the SPAs are still contracts which bind the parties, although they are standard form contracts under Schedule H. And the purchaser's right is not ousted in the SPA because if there was a delay, the purchaser would still be entitled to sue on 36 months. Earlier on, I mentioned that actually the notice of delivery is within 60 months, meaning there was no late delivery by the developer here. The court said, okay, since parties already agreed to 60 months, it's unfair for the purchaser to go back on what they have promised. However, if there was a delay, so let's say the developer in this matter actually delivered the property beyond 60 months, parties, which is the purchaser, will then be entitled to sue on LAD based on 36 months. Now, this is what the court has decided in Alpine. There is no conclusion yet to this case. It's still a live issue before the Court of Appeal. I hear that the Court of Appeal will be hearing this case in October this year. This is something that's still waiting to be developed. We'll see what the Court of Appeal say and whether the Court of Appeal agrees with the view of the High Court judge here. Finally, I touch on these two High Court cases. Very briefly, the conclusion of these two cases are that settlement agreements are full and final settlement of the dispute between parties regarding LAD. Entering settlement agreements do not constitute contracting out of HDA and HDR, and nothing in HDA prohibits settlement agreements. So if developers have already entered into a settlement agreement, or there is a letter saying that we are paying this amount of LAD and the purchasers have already signed and agreed on it, court said that you cannot ask for additional LAD because you've already agreed to that amount. Okay, these are full and final settlement with regards to LAD. It goes without saying that this settlement agreement also has to be on LAD. It cannot be on any other matter. But these are high court cases. We don't know if there will be a reversal or overruling by the higher courts. And as these cases are fairly new, we'll see if there is any development on this. After going through all those cases, these are the conclusions that I've come up with. Although Ang Ming Lee is still the highest authority on LAD, it's a federal court case, there has been some effort by the court to balance the interests of both developers and purchasers. And as I mentioned, the jurisprudence on this is still evolving. Do look out for updates. We do regularly update our website, and we do give talks like this to update everyone, the public, about what's happening. So do look out for the news for anything on this matter. And the key takeaways from the cases are that the minister can still grant EOT. So the minister can, under Section 24 of the HDA, still grant EOT. Settlement agreements are binding, and these are settlement agreements for LAD. Finally, look out for limitation period. So if you are looking to defeat or bring a claim for LAD, and if you want to challenge the validity of the clauses on late delivery, do look out on the 6-year limitation period. And with that, I end my presentation. I see that there are a lot of questions. We will try to go through them one by one and hand over the time to Daphne.
Thanks, Hannah and Ryan. Yeah, I see that we have quite a number of questions. We will try our best to address all of it, but we do have a time limit, so we will address as many as we can. Okay, the first question. There are two portions in the HDA to be handed over to the purchaser SVP, i.e. common area and the actual unit itself. If the unit is not available, but the common area is ready, is it possible to still hand over partially? Hannah, would you like to take this?
The clause that governs the delivery of vacant possession is clause 27, and I'm looking at Schedule H again. Here it says very clearly what must happen before a delivery of VP is given. It doesn't matter whether it cannot be partial that way. So you cannot half-half, because here it says here it has to be after the issuance of the CCC. And CCC can only be issued after the entire project is completed.
Thank you, Hannah. The second question. The HDA is passed by the Parliament to protect a certain section or group of persons. What do you mean by group of persons? Is it meant to protect only weaker purchasers rather than stronger or wealthier purchasers, or both? Ryan?
The wealth of the purchaser does not matter. It's primarily, it's to regulate the business of housing development between a developer and a purchaser. It's a social legislation. The wealth of the purchasers do not matter in this aspect. It goes as far as it can to protect all purchasers, actually.
How about those SPA which is expressly stated to be that the property is to be delivered within 48 months? Hannah?
Standard form is 36 months. If it goes beyond 48 months, it really depends. So if the controller was the one who allowed the extension from 36 to 48 months, then you have grounds to challenge that, to say that it should be 36 months as a result of Ang Ming Lee's case. However, if it's the controller who gave that extension of time, then it may be a tougher task for you to prove that 48 months is invalid. It really depends who granted this extension of time.
Our next question, I believe it means, does vacant possession means electricity and water are ready to be utilized? Could you elaborate? I think Ryan would be taking this.
There is a recent High Court case which says that water must be flowing and electricity must be running. What this means is that when you turn on the water tap, water is actually flowing out from the tap, and when you click switches, the electricity is turning on. So I think that is what it means.
Hannah, what happens if developer delivers vacant possession without the strata title being issued and does not have waiver from the ministry to deliver vacant possession without strata title?
My answer will be the same as the very first one that I answered just now. Go back to the relevant clause in your SPA. What amounts to delivery of VP? If it ticks all the boxes, then no issue. If it doesn't, then there is an issue that you can challenge it.
Thanks, Hannah. Ryan, should limitation be calculated from the date of the SPA or from the date of vacant possession being delivered?
I think this really much depends on the claim. So if the purchaser is claiming for liquidated damages by challenging the legality of the SPA, then the limitation period would start to run from the inception of the SPA. This is what Hannah stated in the case of Obata Ambak previously. But if you are just claiming for LAD without challenging the legality of the SPA, then it would be from the date of vacant possession.
This question would be for Hannah. Is there any way to break the links between the signing of the booking form with the SPA? For example, booking form signed and then later refunded in full, and then the purchaser signs the SPA with full payment of the first 10% of the purchase.
I've personally not seen this in our cases. And from what I have seen through my experience, booking fee in any form, refunded, not refunded, sometimes they're not even called a booking fee. Those are, the court will still take it as a booking fee. Now, whether if it's refunded in full later on, whether it still amounts to a booking fee or not, really depends. Here you mentioned there is a booking form signed and there were some monies that were exchanged or rather paid when the booking form was signed. So it is arguable that it may amount to a booking fee, and if that's the case, then your calculation of delivery of VP will start from that. So I think the short answer is it depends. The long answer is what I've just mentioned earlier.
Thanks, Hannah. Ryan, is it normal for different outcomes to be made by different judges, even though the cases are similar?
This is an interesting one. I wouldn't want to outrightly say that it is normal for different outcomes to be given by different judges, but there have been some instances where there are conflicting decisions. For example, one example would be the case of Alpine, the High Court case previously, which stated that if a purchaser executed the SPA before, if the extension of time by the controller or the minister was given before the purchaser executes the SPA, then the purchasers are stopped from their claim. This is what Alpine said. But in the case of UNE Sanja, it is a Court of Appeal case. It states that estoppel cannot apply because the extension of time was illegal. So it doesn't matter whether the extension of time was given before or after the purchaser executed the SPA. There are times when there are differing decisions, but I think the best approach would be to follow the higher court. Hannah, would you have anything to add on this point?
I fully agree. There are a lot of times. So in fact, Ang Ming Lee's case came about because there were a lot of conflict decisions. Even PJD Regency on booking fee, there were a lot of conflicting decisions before. So what it took was the federal court to decide on one definitive answer. And even then, there are still so many differing views after that. So the short answer is that it really depends, once again, on the facts of your case. But yes, it's quite normal to see different outcomes here and there. But maybe I just want to point out this doctrine called stare decisis. So if there is a higher court which decides on something, the lower court is bound to follow it because it's how the system here works in Malaysia. Unless the lower courts can find a way to differentiate the facts or on the law between the higher authority and the lower authority. So this is how you can see there are a lot of distinguishing decisions, even though there is a federal court Ang Ming Lee case.
What if the developer gets wound up when there are purchasers in the midst of claiming LAD against the developer? Is there a way to secure the LAD money pending the disposal of the suit? And I think another relevant question here would be, is there any limit on an LAD claim?
I can answer the last one. There is no limit as long as you can find a start and end date and there is an amount that you can peg to the start and end, then yeah, that's the amount that you get to claim. There is no cap amount if that's what you're asking. And wound up, if the developer is already wound up, unfortunately, the only way I think you can go about getting your money back is to file in a proof of debt and then get your monies after the Jabatan Insolvency have already distributed the assets of the company. But is there a way to secure the money pending the disposal of the suit? I don't think so. And even if there is, I'm quite sure your one claim is not the only claim for LAD. There are a lot of claims, and I don't think there is a way for every purchaser to secure that amount before they go bust.
And another question, how do we determine the date of the vacant possession? Is it from the date of the CCC or the date of the letter of vacant possession, or the date 5 days after posting the letter informing you that vacant possession is delivered as per clause 32 of Schedule H?
If it's for the purpose of calculating your LAD, we usually take the date of the notice. So let's say your letter of VP is 1st January 2022. That's your notice of delivery of vacant possession.
I think this one will be taken by Ryan. The date of the SPA is 16th of March 2017. The supposed date of vacant possession, 16th of March 2020. The notice of vacant possession, 21st of January 2022. What is the period of delay? Can the developer claim that they have an extension of time due to the COVID period?
First and foremost, if the notice of vacant possession is on the 21st of January 2022, the exemption period, which I stated earlier, would apply. So you would have to take away the exemption period between 18th of March 2020 until the 31st of August 2020. So from there on, if there is no further extension, then LAD should be calculated from the 1st of September 2020 until the 21st of January 2022. I believe that's the answer, as long as there is no further extension from the initial period.
Thanks, Ryan. The certificate of fitness is dated 20th of December 2021, and the notice of vacant possession is actually dated 21st of January 2022. When is vacant possession actually delivered?
Notice of VP, which will be your 21st January date. That's when the developer notify you. That would be your date.
If the property is completed before the due date, but some of the common facilities are not completed, can the owner submit for an LAD claim for common area, or they have to wait until the due date, the actual due date of the property?
Just go back to your contract, everybody. Go open your S&P. It's there. It says there when the time for delivery of vacant possession is given. And it's usually when the notice is given. So that's your start date. Calculation of LAD. Yeah.
Thank you, Hannah. Settlement agreement between the developer and the purchaser should be served to the ministry to notify them on such settlement has been concluded. Or should the settlement just be between the developer and purchaser? Would that suffice?
I think settlement agreement between the developer and the purchaser will suffice. There is no explicit need to send the said settlement agreement to KPKT. I think that there is no need to do that.
If the vacant possession is delivered but title has not been issued for 5 years, can we claim LAD from the developer?
No, because title issue is completely different than, if you're talking about strata title, it's completely different from the delivery of vacant possession. So again, follow your contractual provision that says when VP is deemed to be given. I see here there is one question here. Can the minister sign on behalf of the controller for an EOT? The answer to this is the controller cannot give the EOT. So the minister, if he wants to sign, he signs it on his own accord, not on behalf of anyone. Because regulation 11.3, which regulates that the controller can give EOT, is now considered invalid. Nobody should be signing on behalf of the controller for an extension of time.
We are a little out of time. Thanks, Hannah and Ryan, for sharing your knowledge and for the informative session. Before we conclude, I actually have a few announcements to make. I would like to say, please do join us again for our upcoming talk. We actually have one talk coming up on the 23rd of June on land acquisition for redevelopment projects in Malaysia. It's on a Thursday. Do join us. You can also scan the QR code on the screen to sign up for our online talks. Secondly, please fill up our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow or like our social media accounts. We are actually on YouTube, Twitter, Instagram, LinkedIn, and on Facebook. The links will also be posted on the chat box. Fourthly, if you'd like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link will be posted in the chat box, or feel free to scan the QR code on the screen. Last but not least, to our guests, thank you so much for joining us. We hope you have found today's session informative and useful, and we hope to see you at our next talk.